My name is Tariq Ahmad, and I'm a foreign law specialist here at the Law Library, where I cover South Asia and other common law jurisdictions. This webinar aims to examine in a comparative format how India and Pakistan regulate government actions to shut down the internet. The following outline provides an overview of the key themes and issues that will be addressed during the presentation. The session will examine key milestones and historical timeline of internet shutdowns in both India and Pakistan, including the different forms such measures can take and the various rationales and justifications both governments have advanced for their use. It'll also analyze the constitutional rights affecting those shutdowns and the legal and regulatory frameworks, the laws and rules governing their implementation. And of course, the judicial responses and leading case law that have helped shape their application. The session will also touch on at the end some of the broader economic, social, and political and human rights implications and impacts that these shutdown measures have had on both countries. Now, there are different forms and types of internet shutdowns and various technical methods used by governments and authorities to implement them. These can include total network shutdowns, which can be called a blanket internet shutdown or a total internet blackout, where all internet connectivity is completely suspended. There are also broadband or wired internet shutdowns, which are limited to fixed line internet services. And then there are mobile internet shutdowns, which restrict internet access to of cellular mobile networks. Some shutdowns involve platform or service blocking, where access to specific applications, social media platforms, or online services are restricted or suspended, as well as internet speed throttling, where internet connection speeds are deliberately reduced to such low speeds that it limits the effective use of the internet. Shutdowns can also be targeted. They can be implemented to a particular geographical area, either regionally or locally, such as limited to a certain state or city, or in a time-limited fashion between certain hours of the day. And the shutdown can also be institution-specific, such as schools or universities. There are other forms of online restrictions as well, including contact blocking or removal, but we won't have time to cover this in detail during this presentation. Here's a brief overview of the key milestones in the development and use of internet shutdowns in India and their regulation. Now, the legal basis for such measures can be traced to the British colonial era Indian Telegraph Act, which regulated wired and wireless telecommunications and has been the main statutory framework for close to 140 years until it was recently replaced. India's first recorded internet shutdown occurred in 2012 when mobile internet services were temporarily suspended in the Kashmir region during protests over an allegedly blasphemous film. In 2016, the Kashmir region also experienced its first prolonged internet shutdown lasting 103 days due to unrest and protests resulting from the killing of a commander of a militant group. A major regulatory development followed in 2017 when the government introduced the first specific regulatory and procedural rules governing internet shutdowns under the Telegraph Act. The longest shutdown occurred in the Kashmir region between August 2019 and January 2020, following the revocation of the region's special constitutional status with the restrictions lasting 213 days. Internet shutdowns were also imposed during protests around the country, such as those that were triggered by the proposal and enactment of the Citizenship Amendment Act. And in 2020, the Supreme Court issued its landmark judgment, Anuradha Bhasin, establishing important constitutional limits governing the internet shutdowns. Shutdowns were again used during the 2021 farmers' protests in the capital of New Delhi and in the state of Haryana, among other states, demanding the repeal of the controversial farm laws. And also in 2023, when the Manipur crisis happened, which involved ethnic conflict in the state. Restrictions remained in place for approximately 200 days. And in 2023, the Telecommunications Act and its subsidiary rules were introduced, which updated the legal framework for telecommunications regulations. Now, according to Reporters Without Borders, India has imposed more than 900 internet shutdowns since 2012, and it's often described as the world's leading user of such measures. This slide is a screenshot of an internet shutdown tracker by the Software Freedom Law Center, a digital rights organization, which gives you an approximate idea of the number of internet shutdowns that have happened annually and in total, and the states and regions that have had the most internet shutdowns, as you can see, Jammu and Kashmir. Now, Pakistan's main legal framework for internet shutdown is the Pakistan Telecommunication Reorganization Act, which also established the main telecommunications authority in 1996. Now, the first known instance of a localized internet telecommunications shutdown occurred in 2005 during military operations in Balochistan. In 2012, it's reported that authorities increasingly started to rely on citywide mobile network shutdowns. And between the period of 2012 to 2017, we saw frequent internet restrictions and disruptions associated with military operations in the northern tribal regions, during political sit-ins and protests, during sectarian violence and unrest, and during national and religious holidays. From 2012 to 2016, we also saw a nationwide block on YouTube in reaction to a blasphemous anti-Islam film. Now, in 2018, the Islamabad High Court held that routine suspensions of mobile services were unlawful based on the provisions of the Pakistan Telecommunications Law. This decision was, however, overturned in 2020 by Pakistan's Supreme Court. Now, between 2020 and 2023, we saw frequent shutdowns continue to be used during protests by political and religious parties. Pakistan continued to employ platform-specific blocking like TikTok and content removal restrictions. In 2022, we see a ratcheting up of internet restrictions as the country fell into political unrest and instability surrounding the removal of former Prime Minister Imran Khan. Now, following Khan's arrest in 2023, which also resulted in nationwide unrest and protests, authorities imposed extensive mobile internet disruptions, internet speed throttling, content removal, and blocks on social media platforms such as YouTube, Facebook, and X. Now, during the 2024 general elections, internet throttling and platform blocks continued, while controversy arose over continued blocking of X and reports of a national internet firewall and blocking of VPN use to bypass internet restrictions. We're also seeing various high courts trying to grapple with the legality of these disruptions during this period. Now, in 2025, 2026, internet disruptions remain a part of Pakistan's response to protests, anti-terrorism and insurgency and security operations, particularly in Balochistan and areas connected to the Pakistani-administered Kashmir region. Now, there are a number of rationales and justifications that governments use to impose internet shutdowns. Commonly cited reasons include maintaining public order and protecting national security, particularly during periods of violence, riots, unrest, or security threats, during counterterrorism and anti-militancy operations. We see both India and Pakistan cite this in their justifications. India cited it during the unrest and anti-militancy operations in the Kashmir region, and Pakistan cites this during military operations and counter-militancy operations in the regions of Balochistan or the northern tribal region. Governments may also justify shutdowns as a means of preventing potential religious violence or communal tensions, restricting or controlling public protests and demonstrations, or addressing concerns related to elections and election-related disruptions. We saw this in India during protests and violence against the anti-citizenship bill and the farmers' protests, and of course, the ethnic violence in Manipur. And of course, we saw this in Pakistan during political instability and violence during the removal and arrest of Imran Khan, and protests involving far-right religious groups like Tehreek-e-Labbaik. In some instances, shutdowns can also be imposed during national or religious holidays or during religious processions to prevent security or communal incidents. This happens in Pakistan during the month of Muharram, another frequently cited justification is the need to prevent the spread of misinformation or disinformation online that the government argues can spiral into unrest. In addition, some governments, particularly India, have used internet shutdowns to prevent cheating during public examinations, competitive examinations, by limiting access to online communication and information sharing platforms. Now, internet shutdowns can affect a number of fundamental rights protected under India's constitution. Most notably, Article 19(1)(a) guarantees the freedom of speech and expression. The Supreme Court has held in the past that online speech enjoys the same constitutional protection as offline speech. And human rights advocates have frequently argued that freedom of speech, including online speech and social media platforms, are becoming essential for the functioning of a democratic society. Freedom of press and media, it enables the exchange of ideas, the criticism and accountability of the government, and of course, a development of a more informed public. However, this right is not absolute. Under Article 19(2), the state may enact and maintain laws that impose reasonable restrictions in the interests of sovereignty, integrity of India, the security of the state, public order, decency or morality, and the prevention of incitement to an offense, among other grounds. In later slides, we'll see how the Indian judiciary has sought to balance internet freedom with states' national interests. Beyond freedom of expression, internet shutdowns may also affect other constitutional rights, including the freedom to practice any profession or carry out any trade or business. Internet access is now closely tied to work, professional life, commerce, and trade. And then, of course, right to security of person and privacy, as well as digital platforms support essential public services, social welfare, and of course, the right to education, particularly when access to learning is increasingly dependent on internet connectivity. Pakistan's constitution also contains a number of fundamental rights that are frequently invoked by petitioners and considered by courts in challenges to internet shutdowns and online restrictions. These include Article 19, which protects freedom of speech, expression, and the press, as well as Article 19(a), which guarantees the right to information. However, like its Indian counterpart, Article 19 is not absolute and is subject to reasonable restrictions imposed by law in the interest of the glory of Islam, the integrity, security, and defense of Pakistan, decency and morality, amongst other grounds. Internet shutdowns may also implicate Article 18, similarly, which protects the freedom to engage in trade, business, professional life, and then, of course, also Article 19, which guarantees the security of person right to life. Now, as I previously mentioned in the previous slide, arguments have been made that internet access has become such an essential in terms of providing essential services, healthcare, emergency healthcare, online banking, payment systems, without which could jeopardize personal health, safety, and the well-being of citizens. Now, India's legal and regulatory framework for internet shutdowns is based on several laws and rules that authorize authorities to restrict telecommunications under specific circumstances. One key provision is Section 144 of the Code of Criminal Procedure, 1973, which empowers district-level executive magistrates who are primarily responsible for maintaining law and order to issue temporary orders in urgent cases of nuisance or apprehended danger. Now, this provision has been invoked to maintain public order, prevent riots, and address communally charged violence. The code has since been replaced by a new code, which came into force in July 2024, but it contains a similar provision. Now, this provision was widely used in the early years as a legal basis for district-level internet shutdowns. However, its use appears to have declined following the Supreme Court's 2020 decision, which widely interpreted as indicating that internet shutdowns should be imposed under federal telecom suspension rules rather than through Section 144 orders. Another important law is the Indian Telegraph Act, particularly Section 5(2), which authorizes the central or state government to detain, intercept, or suspend the transmission of messages. This provision is used to suspend telecommunications during a public emergency or in the interest of public safety when justified on certain grounds such as sovereignty or the integrity of India, the security of the state, public order, amongst other grounds. Now, civil society organization and digital rights advocates criticize the lack of clear and consistent legal standards governing internet shutdowns and what they view as the arbitrary nature of their use. For example, key terms such as public emergency, public safety were not clearly defined in the law, leaving significant discretion to the authorities. Critics also raise concerns over the opaque nature of the decision-making process, the lack of transparency regarding the reasons used to justify shutdown orders, and the limited public disclosure of those reasons. In addition, there were concerns about the potentially indefinite duration of shutdowns, as well as an absence of robust accountability mechanisms and independent review processes to oversee such orders. So in 2017, the temporary suspension of telecom rules were a legal and procedural framework for issuing telecom suspension orders. The rules specify that the competent authorities authorized to issue shutdown orders, the Secretary in the Ministry of Home Affairs at the union level, and the Secretary in charge of the Home Department at the state level. And what the rules describe as unavoidable circumstances where prior approval is not feasible, a joint secretary level officer may issue an emergency order. However, such an order must be confirmed by the competent authority within 24 hours, failing which the order automatically lapses. The rules also require that all suspension orders be issued in writing and include reasons for the restriction. In 2020, the rules were amended to impose a maximum duration of 15 days for telecom suspension orders, ensuring that shutdowns remain temporary rather than indefinite. This amendment was introduced following the Supreme Court's landmark judgment in Anuradha Bhasin. Furthermore, the rules establish institutional safeguards through a review committee, which must meet within 5 working days of issuance of a shutdown order and determine whether it complies with Section 5(2) of the Indian Telegraph Act and record its finding. Finally, the rules require telegraph authorities and service providers to designate nodal officers in every licensed service area, state and union territory to receive and process shutdown orders. A significant legislative change occurred with the enactment of the Telecommunications Act 2023, which repealed the Indian Telegraph Act. While the new act attempts to modernize India's telecommunications legal framework, it largely preserves the government's authority to suspend telecommunications during a public emergency or in the interest of public safety. The grounds for such suspension also remain substantially unchanged, including the protection of sovereignty, the security of the state, public order, as before. And also in 2024, a new set of telecommunication suspension rules were also issued, which continue many of the procedural safeguards established under the earlier regime. The rules retain the requirement for that suspension orders be issued by designated authorities, remain subject to review by a review committee, be limited in duration to a maximum of 15 days, and be implemented through designated nodal officers. However, the updated rules introduce several important transparency and accountability measures. Unlike the 2017 rules, they expressly require that suspension orders be published and made publicly available, enabling affected individuals, civil society organizations, and the courts to scrutinize the basis for restrictions. The rules also require that orders contain a clear rationale, be narrowly tailored to address the specific circumstances giving rise to the suspension, and identify the precise geographical areas affected by the disruption. Review committees are now established at both the central and state levels, and the rules make clear that these committees may set aside an order if it is found to be in violation of the Act. These changes are intended to ensure that internet shutdowns are more targeted, proportionate, transparent, while reducing the risk of overly broad or indefinite restrictions. Now, despite these reforms, concerns continue to be raised by the courts, civil society groups, and digital rights advocates regarding the need for greater oversight and accountability in the use of shutdown powers. For example, an analysis done by Digital Rights Foundation, a digital rights advocacy organization, has found that the review committees consist solely of executive officials and do not include independent members such as judges, former judges, technical experts, or civil society representatives. In addition, while the rules impose temporary limit on individual suspension orders, they do not prevent the issuance of successive orders that could effectively prolong a shutdown. Critics also note that the rules do not expressly require the review committees to assess the necessity and proportionality of suspension orders as mandated by the Supreme Court. Sorry, just getting some water. Pakistan's legal and regulatory framework for internet shutdowns is primarily based on the 1996 Act. Now, Section 54 of the Act authorizes the federal government to intercept communications on national security grounds and to suspend telecommunication services upon the proclamation of an emergency. Now, Section 64.3 states that if the president of Pakistan proclaims a national state of emergency, the government has the power to modify existing telecom licenses, suspend network operations, or shut down telecommunication services entirely. Now, under a separate section, Section 8.2c, the federal government may issue policy directives to telecommunication authorities on matters of national security, which the authority is required to comply with. As we will see in subsequent slide, these two statutory provisions become a subject of judicial disagreement over whether the second provision is subordinate to and must follow the rules of the first provision to suspend internet services, or whether they can operate independently. One of the key issues was that one provision carries the additional requirement of a formal declaration of emergency before it can be invoked. In practice, the process leading to a shutdown typically begins with a request from a state government, law enforcement agencies, intelligence agencies, or other government bodies to the Ministry of Interior. The Ministry of Interior then issues directions for restrictions or suspension of services which are implemented by the Pakistan Telecommunications Authority, and then executed by telecommunications operators. In addition to network level shutdowns, the Prevention of Electronic Crimes Act provides authorities to powers to block, remove, and restrict access to specific online content and websites. As a result, Pakistan's regulatory framework provides the government with tools both to suspend telecommunication services more broadly and to censor and restrict access to particular online content. Now, this legal and regulatory framework has been heavily criticized on several grounds as well. Authorities have relied on broad and vaguely defined concepts, such as national security and public order, giving them broad discretion to issue far-reaching shutdown orders. Critics have also questioned whether the underlying statutory provisions clearly grant the government the authority to suspend internet services at all. In addition, the framework lacks procedural and substantive safeguards, including transparency regarding the rationale for shutdown orders, limits on their duration, geographical limits, and the mechanisms or review bodies to ensure that such measures are necessary and proportionate to the threat being addressed. In recent years, there's also been significant controversy over the installation of a web monitoring system, often described in the media as internet firewall, and viewed by critics as a key component of Pakistan's internet censorship and surveillance infrastructure. The WMS is a centralized internet monitoring and content filtering blocking system operated by the Telecommunications Authority and reportedly deployed in news reports at Pakistan's international internet gateways and other critical internet infrastructure. Now, according to media reports, this system enables centralized monitoring, filtering, and blocking of online content, and through what is called deep packet inspection technologies, which allows you to actually see the content of the data, authorities can reportedly have more of a granular control over an ability to block and suspend specific URLs, websites, specific functions within applications themselves, and then of course also target and disable VPN use. The system was procured in 2018 from a Canadian company. In late 2023 and 2024, news reports have stated that it's been reportedly been upgraded, with some reports attributing the upgrade to Chinese technology. The upgrade became controversial after journalists, digital rights advocates, and business groups linked it to widespread internet shutdowns and disruptions across the country. Allegations which were denied by the government authorities at the time. The issue was also raised in litigation before Pakistani courts as petitioners sought clarification regarding the causes of the degraded internet speeds. Now, Indian superior courts have played an important role in defining the legal and constitutional limits of internet restrictions and shutdowns. In this presentation, I'll try to go over some of the landmark judgments that sought to provide judicial oversight of such measures. In the case of Fahima Shireen, the Kerala High Court considered a challenge to rules in the female dormitory that restricted students' access to mobile phones between 6 p.m. and 10 p.m. The petitioner was a female student who refused to abide by the rule and declined to sign an undertaking requiring students to comply with it. The court held that access to the internet is a fundamental right closely linked to the right to education, the right to privacy, protected under Article 21 of the Constitution. The court found that the rule constituted an unreasonable restriction, observing that the use of mobile phones as part of the day-to-day life and modern educational resources are more easily accessible through them for acquiring knowledge, conducting research, and completing assignments. The court also noted that the college students are mature enough to manage their own time and studies. Further, the court cited international human rights standards, including resolutions of the Human Rights Council and the General Assembly, recognizing the essential role of the internet in promoting freedom of opinion and expression and advancing women's empowerment. Now, the Supreme Court landmark decision in 2020 arose from a number of challenges, including one brought by a journalist, to the internet and communication restrictions imposed in the Kashmir region following the revocation of the region's special constitutional status in 2019. The government argued that restrictions were necessary to prevent terrorism and maintain public order, citing the history of cross-border terrorism and militancy in the region. It contended that the measures were required to protect lives, maintain security, and prevent the circulation of messages that could provoke or incite violence. The restrictions were imposed under Indian Telegraph Act and its subsidiary temporary rules, 2017, as well as provisions of the Code of Criminal Procedure related to law and order. Now, the court first observed that the petitioners had not argued for the recognition of a standalone fundamental right to access the internet, and therefore it expressed no view on that question. Instead, it confined itself to declaring that the rights to freedom of speech and expression and to carry on any trade or business using the medium of the internet are constitutionally protected. The court held that access to the internet is integral to the exercise of such rights, and these activities are increasingly dependent on internet access. The court first ruled that government must publish all orders imposing restrictions. Shutdown orders must be made public to enable affected persons to challenge them. It observed that the difficulty to determine the legality of restrictions when authorities refuse to produce the orders imposing them. The court reasoned that the freedom of expression includes the right to information and that this interest must be weighed against the state's claim of secrecy. The court further held that internet shutdown orders are subject to judicial review. The court held that although the government could suspend internet services and that national security and public law order are legitimate government objectives, it must demonstrate that the necessity and proportionality of any restriction. The court noted that the 2017 rules did not contain a temporal limit and held that indefinite suspension of internet services is impermissible. All suspension orders must comply with the principle of proportionality and therefore have to have a time limit. The court also directed the government to review all existing suspension orders, and any order found to violate the principle of proportionality or lacking temporal limits was required to be revoked. The court also observed that Section 144 of the Code of Criminal Procedure, which authorizes restrictions on public assemblies, is intended as a remedial and preventive measure to address imminent threats to public peace. However, it cannot be used to suppress legitimate expression or the exercise of democratic rights. In 2020, the Supreme Court of India again addressed restrictions on internet access in the Jammu and Kashmir region. The case arose from petitions filed by the Media Professionals Organization and lawyers seeking to restore 4G mobile internet services, which remain restricted and limited to 2G speeds during the COVID-19 pandemic. The court observed that fundamental rights of citizens need to be balanced with national security concerns. While recognizing the government's concerns relating to cross-border terrorism and militancy, the court questioned whether restrictions needed to be applied uniformly across the whole region. Rather than striking down the restrictions or directing immediate restoration of 4G services, the court directed the establishment of a special committee to review whether continuation of the restriction was necessary and whether it could be limited to areas where it was genuinely required. Now, there are other internet shutdown cases as well that involve examinations, school examinations. Now, the Calcutta High Court considered a challenge to internet shutdowns imposed during Class 10 board examinations competitive to prevent cheating. The court held that the state had failed to show lawful authority and sufficient justification that the order did not demonstrate that the existence of a public emergency or public safety required by the law. The court also found that the shutdown failed the proportionality test as it imposed a blanket restriction affecting the general public, including banking, education, and business activities, while addressing a relatively narrow concern of exam malpractice. Further, the court noted that the order lacked adequate reasoning, relying only on general references to unlawful activities based on intelligence information. In 2024, the Jharkhand High Court ordered the restoration of internet services suspended during a graduate level competitive examination. The court held that such statewide restrictions could not be imposed merely by adding terms such as public interest or fair examinations in an order without concrete factual evidence. It further directed that internet services should not be suspended for examination purposes without prior judicial permission. The state had initially suspended only mobile internet, but later extended the restriction broader to other internet services, which the court viewed as being disproportionate. And of course, there are also protest-related cases as well. In one high court case during protests against the Citizenship Amendment Bill, the High Court ordered restoration of mobile internet services in Assam. The court held that the state had failed to demonstrate a continuing necessity as there was insufficient evidence of an ongoing threat to public order, justifying the continuation of the restriction. The restriction was like a week-long restriction, and they felt that the threat level had dissipated, so it was no longer necessary to keep the restriction imposed. Now, in 2018, the Islamabad High Court heard petitions brought by telecommunications companies challenging the frequent suspension of mobile phone services and as unlawful and unconstitutional. The petitioners argue that the suspensions violated Section 54.3 of the Pakistan because no formal declaration of emergency as required under the Constitution had been issued by the president. They further argued that the suspensions infringed fundamental rights guaranteed under Articles 9, security of person, right to fair trial, freedom of movement, freedom of assembly, freedom of association, freedom of trade, business, or profession, freedom of speech, and then the right to information. And they stated that the access to telecommunication services internet has become a fundamental right. The federal government and Pakistan's Telecommunications Authority argued that the suspensions were authorized under Section 55.3 through directives issued under Section 82C, which permits the federal government to issue directions to the PTA on matters related to national security. I'm just going to move to the next slide just to give you a better sense of what the actual provisions say. Now, as I mentioned, the authority argued that suspensions were authorized under Section 54.3 through directives issued under Section 82C, which permits the federal government to issue directions to the PTA on matters related to national security. Now, the court held that the phrase "not inconsistent with provisions of the Act" in Section 82C meant that the provision could not be read independently of Section 54. Any directive issued under Section 82C therefore had to comply with the requirements and procedure set out in Section 54.3. However, as no presidential proclamation of emergency, which is regulated under the Constitution, the court found that the suspension order was to be unlawful and without legal authority. Now, in 2020, the Supreme Court of Pakistan overturned this decision and held that the High Court had reached a hasty and incorrect conclusion by misreading the law. The Supreme Court found that the High Court had incorrectly made Section 82C subordinate to Section 54.3, despite the two provisions serving different purposes. According to the court, Section 54.3 grants the federal government authority to suspend when a constitutional emergency has been declared and is therefore reactive and defensive in nature, quote unquote, applying to grave situations that may require extensive and prolonged disruptions. By contrast, Section 82C concerns matters of national security that may require preemptive action before a threat materializes and may involve localized and temporary service suspensions. Reviewing examples of orders in the past, the courts that the government had issued, such as sectarian tensions during religious holidays, security concerns during national events, protests, and incidents of religious violence, the court concluded that there was a legitimate government need for such measures. It held that where such circumstances justified the issuance of suspension orders, they would be in the public interest, reasonable, fair, and consistent with the object of the law, and therefore valid. Now, the Sindh High Court internet disruption case happened in 2024. A petitioner, Muhammad Jibran Nasser, a lawyer and a human rights activist, who is also a candidate for elections, challenged disruptions to broadband and mobile internet services, as well as blocking of social media platforms, arguing that they hindered an election candidate's ability to communicate with voters, restricted the voters' access to information, and undermined the fairness and transparency of elections. In January 2024, the court directed the federal government and the Telecommunications Authority to ensure the uninterrupted access ahead of general elections. In February, the court observed that its earlier orders had not been complied with and that no valid reasons had been provided for the disruptions before and during the elections. It therefore directed that there should be no further shutdown disruptions unless valid and cogent reasons were provided. During a hearing in March, the the Telecommunication Authority explained that the Ministry of Interior had requested the suspension of mobile services and that the authority was legally obligated to comply with such directives. In April 2024, the court again directed the government to justify the restrictions or restore the access to X, formerly known as Twitter. The government cited national security concerns, arguing that hostile online elements were seeking to create an environment of chaos and instability. Now, the Lahore High Court also in the same year also heard petitions concerning internet disruptions, reduced internet speeds, restrictions on VPN services. The court repeatedly summoned relevant government officials and regulatory authorities to explain the legal basis for the disruptions and the restrictions. Now, reports indicate the internet shutdowns in India have imposed significant economic costs, with monitoring organization estimating losses amounting to billions of dollars over recent years. Now, beyond these direct financial losses, organizations have cited that internet disruptions have negatively affected India's digital economy by disrupting digital e-payment systems, everyday financial transaction, e-commerce, and of course, the work of gig workers, while also impacting small businesses and freelancers. Human Rights Watch has also reported that shutdowns have disproportionately affected poor and vulnerable communities, particularly women, which increasingly rely on digital platforms to access essential public services and welfare programs. There have been reports and discussion on how internet shutdowns undermine investor confidence and raise concerns about the reliability of India's digital infrastructure, particularly in the context of the government's ongoing Digital India initiative, which seeks to expand digital infrastructure, facilitate a digital delivery of government services, and promote universal digital literacy. Substantial economic costs can also be shown for Pakistan as well. Reports indicate that internet shutdowns have imposed substantial economic costs, with estimated, and as well, and in 2024, it was reported that Pakistan incurred the highest financial losses of close to $1.62 billion. Estimates suggest that a complete nationwide internet shutdown can cost the economy roughly 19.1 million a day, while some estimates as high as 53 million per day. While partial internet or platform-specific shutdowns may result in daily losses ranging from 2.6 million or 4.2 million. According to the Pakistan Institute of Development Economics, a complete suspension of 3G or 4G mobile services costs approximately 4.6 million per day. Beyond these direct financial losses, similar to India, the internet disruptions have reportedly negatively affected Pakistan's digital economy, disrupted businesses, the IT sector, e-commerce, the work, of course, of freelancers and gig workers who rely on stable internet connectivity for their livelihood. Now, as we kind of reviewed during some of the case law as well, beyond economic consequences, internet shutdowns in India and Pakistan have also significant social, political, and human rights implications. Such measures are often criticized as a form of censorship that stifle dissent and restrict freedom of expression and press, particularly affecting journalists, activists, lawyers, and civil society actors. In India, the extended lockdown in Kashmir regions, internet shutdowns during protests involving the Citizenship Amendment Law, and the farmers' protests were criticized for limiting communication, access to information, and of course, the ability to organize and report on demonstrations and alleged human rights abuses. In Pakistan, election-related internet and mobile service disruptions have similarly raised concerns regarding political participation from both candidates and citizens, access to information, and of course, transparency. Reports have also shown, as noted earlier, shutdowns can also impair access to education, healthcare, other essential services, which can have broader social and psychological impact on affected communities, particularly vulnerable sections of society, by increasing isolation, uncertainty, and stress. And there are several reports that I've linked to this PowerPoint that talks on these issues. Okay, that brings my webinar to a close. Let's see if you have any questions. I'm happy to take them now. Let's see. A second. So one question that we have is, I noticed that in India, the number of shutdowns appears to be declining. Any explanation for this? Yeah, I noticed that as well. I looked into this, but I couldn't find a definite answer. Internet shutdowns in India seem to have gone down compared to some of their peak years a few years ago, though they still happen quite often by global standards. I think India still ranks second in the number of shutdowns in 2025, according to a report by I think Access Now. One reason may be that I'm just speculating here. Policymakers may be more sensitive to some of the economic costs that disruptions cost. It may be that the government is focusing on other tools like blocking specific apps or removing online content. Maybe another possible reason is that there have been fewer larger scale or prolonged security crises compared to earlier years. But of course, as I mentioned, shutdowns have not stopped. They still happen in certain situations like communal and ethnic violence, protests, religious holidays. Maybe they're just not as widely or frequently used as before. In other words, it may be like a relative decline rather than something sustained, like phasing out of their use. Here's another question from Jenny. Could you provide more details regarding the different approaches of the Supreme Court of India and the Supreme Court of Pakistan? It appears the Supreme Court of India places more constitutional constraints for internet shutdowns, while Supreme Court of Pakistan focused more on statutory interpretation and generally seems to have more deferential attitude towards authorities for national security and public order justifications. This is a very good question. I think it's important to understand that we're dealing with quite different political contexts. Pakistan has a political system in which the military has historically played a more dominant role, and of course it still does. And the judiciary has generally considered more deferential and shown more restraint when it comes to matters framed involving national security and public order. And this was particularly evident, as I mentioned, in 2023 and 2024, following the removal and arrest of former Prime Minister Imran Khan, which resulted in protests from his political supporters. And of course, there was implementation of military-backed, according to reports, political and constitutional reforms. So in such circumstances, courts have tended to adopt a more deferential posture towards executive actions, especially where internet restrictions and other security measures were imposed, maybe opposed from intelligence and security agencies. Nevertheless, as we saw, there was definitely some pushback from high courts around the country, especially when governments were not providing clear reasons and justification for internet shutdowns, platform blocks, and then of course the internet firewall, which was according to reports, was being blamed for slowing down the internet. Here's a question about the Sindh High Court order. Why was the federal government not complying with this and directing it to lift internet measures and unblock X? Yeah, in one sense, the court was being forceful. They're repeatedly asking the government to explain yourselves. So it wasn't more of like it wasn't like a firm direction from the court to lift the internet restrictions. They're basically saying, either explain yourselves clearly why you impose these measures or lift them. I think the government decided that they will rather wait it out in court proceedings and provide a variety of vague explanations. And as I mentioned, the authorities said that they had no choice but to follow the directives of the Ministry of Interior, while the ministry argued that these measures were necessary for protecting national security. Or it was a technical issue, like increased usage of VPNs was causing the slowdown. Um, and then even at some point, I think the Ministry of Foreign Affairs chimed in and said that there was no shutdowns at some point. So there was a variety of explanations being given, I think, some of them conflicting as well. Yeah, this is a good question. Has the Indian court defined nuisance as a justification of Um, some of these words that are used in the laws, whether it's in the Code of Criminal Procedure and in the Telecommunication Act, one of the main criticisms is that they're so broad that it provides authorities with fairly wide discretion. As far as I know, if I remember correctly, I don't think nuisance was specifically defined within the code. But I'm happy to look into that. And get back to you. But a lot of the language, both in the code and in the Telecommunication Act, are so wide, or they don't have particular definitions that gives the authorities fairly wide discretion when it comes to actually imposing some of these measures. I would have to look in. This is one question. Have there been developments in India and Pakistan for VPN, proxy service, or other privacy-related internet tools? I'll have to look in that more. I do remember that in during this period, the 2024, 2025, there was increased use of it, and then I think there came a point where the so-called internet firewall was increasingly being used to block some of this VPN usage. I don't know if there have been any later updates on this particular issue. Here's a question. Given the variety of cases listed, are decisions of Supreme Court of India or the Federal Constitutional Court of binding on the governments, these states on a case-to-case basis or with preemptive effect only in matters of similar nature? Definitely decisions on the court superior judiciary are binding on the government, but oftentimes what usually happens is, like, for example, the Islamabad High Court decision, usually these issues are happening at the same time, and usually uh, uh, on these ongoing court proceeding, one date replaces another date, and so there's no final order to actually create or establish a final judgment. I don't think there was a final judgment in Islamabad High Court case. Some of the restrictions were lifted later at a date when security concerns were dissipating. So it matters in one situation. Some situations that there are final judgments then that the governments do follow. But in some cases, the government, like for example in Pakistan, continues to argue it in court and sometimes do not lift the restrictions or justify them on the basis of national security concerns. Here's a question about advocacy actions by civil society in either Pakistan or India regarding the shutting down of internet access from commerce representatives, online banking facilities, when online banking facilities are compromised. I think so. I haven't looked at it too closely, but I do remember a lot of discussion when when the internet was really slowed down in Pakistan, and particularly there was business advocacy groups that came out in front and saying how negatively it was impacting their businesses, the IT infrastructure, the IT sector. So definitely there has been advocacy groups often speaking out to the media, releasing statements, but I don't remember any specific commerce organization that may have come up, but I'm sure they have. They have. Have there been differences along federal lines, such as union territory versus state provinces, autonomous admin divisions? I mean, I think if we look at the earlier use of internet shutdowns, maybe you can say this applies both to Pakistan and India. You see them more increasingly used in areas where there was problems of militancy, problems of insurgency groups, but then in more recent years, things started applying more widely towards other states as well as where there are more higher population, major cities, where there are protest movements, sit-ins, other forms of political and ethnic violence. So you see the net of their usage widening since the earlier years. So there has been a kind of a kind of that kind of trajectory in terms of how they were used earlier on, how they're increasingly used, and then in recent years as well. I guess as nature of conflict changed, also in the nature of the powers and the technical ability for the governments to actually impose these restrictions as well, the technological changes and means. Okay, that's about it on my end. Thank you so much for attending this webinar. If you have any other further questions for me that I wasn't able to answer today, and I can look into, we do have an Ask a Librarian feature on our library website, and I'm happy to look into it further for you in terms of other questions that you may have on this webinar as well. Thank you so much and have a nice day.